Getting a case heard. There are two parts to the Supreme Court case process. There's the selection of the case and then deciding the case. Now up here I've put or legislating from the bench. What I mean by that, decisions of the Supreme Court shape public policy in America, which could be considered overreach of their power because they're only supposed to interpret law, not really write it. The courts are not a very democratic institution because they don't have to react to the majority will, but the courts are not entirely independent of public opinion. Some judges, especially those that are considered activists, actually weigh what the public wants or where modern society is going when they make their decisions. There are three eras of the Supreme Court or trends that you can follow. From 1789 to the Civil War of the 1860s, most of the dominant questions before the court considered the strength of the federal government over the states. So think about like Marbury versus Madison, McCulloch v. Maryland, Gibbons v. Ogden. All of those decisions made the federal government more powerful and defined the federal government as supreme over the state governments. Also, a lot of those the cases dealt with the legitimacy of slavery, like Dred Scott. From the Industrial Revolution to the New Deal, the questions really became about the relationship between the federal government and their involvement in the economy. So how involved should the federal government be in regulation, like Munn versus Illinois? And then the modern era, from post-World War II to today, most of the issues before the court deal with personal liberty and social and political equality. The first step in the Supreme Court case process is to even get the case considered. That's where the Solicitor General does play a role in this. The Solicitor General is the third from the top in the Department of Justice. So you have the Attorney General, the Deputy Attorney General, and then the Solicitor General. Solicitor General has four roles. Really, they're the lawyer for the United States. They decide whether to appeal a case the government has lost in the lower courts to the Supreme Court. They decide to review and modify the briefs presented in government appeals. Third, if the United States government is one of the litigants, like in a case of U.S. versus Nixon or U.S. versus Windsor, the Solicitor General is the one who's going to represent the federal government. 4, the Solicitor General can submit a brief on behalf of a litigant in a case in which the government may not be directly involved, but that the government is kind of rooting for one side or the other. Ultimately, the Supreme Court decides very few cases, and that's the beauty of appellate jurisdiction. Like original jurisdiction, you don't have a choice of what case you consider, but in appellate, you get to pick and choose. The Supreme Court is going to choose cases that have constitutional questions that need to be answered, or cases that have had a high interest, like a case dealing with civil liberties or civil rights. Like same-sex marriage has a constitutional question. Is banning same-sex marriage a violation of that couple's right to 14th Amendment equal protection? Lower courts, if two lower courts have taken different positions on an issue, like the Ninth Circuit Court and the Fourth Circuit Court have taken two separate opinions on an issue dealing with same-sex marriage, then really it's the Supreme Court that's got to make the last and final decision. So if two circuit courts have conflicting opinions, it ends up in the Supreme Court's lap. But it's not a guarantee, because the next step is you got to review the case in conference. In this case, in this conference, the judges meet once to twice a week, and they review cases that their clerks or the Solicitor General have summarized for them. They discuss it. So they discuss the merits of hearing the case or not. If the case is put on the discuss list, then that means the Supreme Court wants to actually hear it. They're interested in it. If it's on the dead list, then that case is dead. It's not going any further. About 1,000 cases are considered for this list, but only 1% are actually heard. Now, how do you actually get a case heard? It takes the rule of 4. If 4 justices agree to grant review of a case, it can be scheduled for oral arguments or decided on the basis of the written record. So the judges can just look at the past briefs and the past court cases, read over them, and make a decision, or the justices can decide to have the lawyers come in front of the Supreme Court and actually argue the case. Nonetheless, out of the 9 judges, only 4 of them have to agree that they want to listen to this case and rule on it. Rule of 4, if your case gets heard, then chances are it's granted writ of certiorari, where the lower court's decisions are made certain. A writ of certiorari is a formal document that calls a lower court's case to be placed on the Supreme Court docket or schedule. So when you're granting writ, you're bringing the case up. All of the facts, all of the briefs, all of the amicus curiae briefs, you're bringing it up from the circuit courts and you're placing it in front of the Supreme Court and you're getting it ready for oral arguments. If your case is denied cert or writ of certiorari, then the lower court's decision stands. Again, cases that involve major issues are likely to be selected by the court. The court has tried to avoid certain political issues like ones between President and Congress, but sometimes they have to answer those as well. Now, once your case has been granted writ or your case is on the Supreme Court document or the docket, you have to submit your briefs. Okay. Remember, briefs are the facts of the case or the case paperwork. So these are pictures of, you can see these are just spiral bound books of information labeled by the case. And the justices, they look over these briefs, They look over these briefs in the 2 weeks in between oral arguments. So there's a 2-week cycle. There's 2 weeks between oral arguments, and the 2 weeks that they're off, that's when the Supreme Court justices have to review the facts of the case. So they sit there. It's not like they're not working. They're sitting in their office and they're reviewing briefs. Okay. They want to know what all of the facts are. So the litigants' briefs are prepared prior to oral arguments, and justices prepare questions that they're going to ask the lawyers during the oral argument process based off of the information the justices find in the briefs. So it's kind of like reading a book before you go to a book club, because when you go to your book club meeting, you got to talk about the book. Well, you can't talk about the book unless you know all about it. So the justices, they're sitting there, they're reading. Let's pretend we're back in the 1950s with Brown v. Board. The justices are reading all of the facts of the case behind Brown v. Board, and they know about the case before the lawyers even come in front of them. That's so that they can prepare questions for those lawyers when the lawyers are actually in front of them. Amicus curiae, also, this is when interest groups will file their briefs, and justices can choose to look at these briefs to see if there's any additional information that might be helpful to an understanding of this case that's presented from that third party. Again, the Solicitor General can submit a brief when the government is interested in the outcome of the case. So, the next step is oral arguments. So the judges have read the facts of the case, they've read both sides' lawyers' briefs, they've read the amicus curiae briefs and the Solicitor General's briefs, and now they're prepared to actually talk about it. Each lawyer gets a half an hour to address the court. They basically summarize their brief and their argument, and they put forward their best arguments, and they have to talk quickly too, because they're going to get interrupted and questioned by the judges. The Solicitor General can also have a chance to argue in cases where the federal government is concerned about the outcome. Judges are not polite. Some justices sit back and listen or fall asleep like Clarence Thomas. Others listen and ask helpful questions to get the lawyers to come up with their best arguments. The judges can request information from the lawyers to help the lawyers make a point. And sometimes the justices just sit there and talk to each other. So I kind of like, if there's a person that you're rooting for, there's a side that you're rooting for and you're a justice, you can ask that lawyer for the side that you're rooting for the questions that you know are going to lead to the best arguments. That's the point of reading the briefs, so you can help a lawyer out when they're in front of you. Okay, it's going to do this wave thing. All right, interesting. All right, the fifth step, conferences. So after the oral arguments, the justices hold a conference. This conference is led by the Chief Justice, and John Roberts is going to invite discussion on the oral arguments and the case briefs. You get to talk based on how long you've been on the court. So John Roberts goes in order of seniority. So the last two people that would be able to talk would be Sonia Sotomayor and Elena Kagan. And in this conference, the justices are going to debate the merits of each side. They're going to refer to the constitutional arguments, the interpretation. They're going to refer to the oral arguments. And then they're going to take an informal vote. They're going to get a general sense of who believes what, which justice believes that something is, which justice believes which side of the case. This is kind of where you get a general sense of what the majority opinion is going to be or what the minority opinion is going to be of the case. So if we took the case of Brown v. Board, you go around the table, you get a sense of who supports the case and who doesn't, and then from there you know more or less what the ruling's going to be. But that's not the final step. The final step is the decision or opinion writing, and I'm going to stop there, and I'm going to take this on Getting Cases Heard Part 2.